We've been talking for a bit about character evidence and the notion that the law, if it doesn't outright prohibit character evidence, at least puts very strong limits on it. That's what we saw from 404A1, in which we learned that the law really disfavors using the past as a prediction of the future, at least when we're talking about the actions of people. Then 404A2 told us there were times when we had to break this generic rule down a bit. There had to be a few exceptions to this. So 404A2 tells us that, look, there may be times when character's actually at issue, in a libel case, for instance. And then there may be times when character is just going to be the best we can do. In a case of first aggressor, who punched who first, who stabbed who first, we may have to rely on character evidence because there might not be a witness to the stabbing or the punching. And so, other than the defendant himself on trial, and so we might need to rely on something like character evidence to actually figure out what happened. But we get the sense coming out of 404A that the law is going to very carefully regulate and limit the use of character evidence. And I've previewed for you before that any sense that character evidence is not going to be admissible, or is at least going to be very carefully limited, gets kind of thrown out the window when we get to 404B2. 404B1, and let me share the screen so we can actually be looking at the rule. And there we have it. And this is the view that you'll have if you go to print a document from Chartacourse. We have 404B, and let's take a look first at 404B1. And in that provision, we learn, much like we learned in 404A1, that there appears to be a strong presumption against the admission of character evidence. 404B1 says that evidence of a crime, wrong, or other act is not admissible to prove a person's character or to show that on a particular occasion he acted in accordance with that character. That sounds really strong. That sounds like this is not going to happen. That sounds like a reiteration of 404A1. But now we move to 404B2, and this is where it all breaks down. The rules will define that the particular uses we're about to identify of evidence is that this use of the evidence is not character evidence. But as you'll see, that's one of those legal fictions. We are absolutely, for all practical purposes, using character evidence under 404B2. It simply says permitted uses will go up. Permitted uses of crimes, wrongs, or other acts. Permitted uses under B2, other acts, wrongs, etc. This evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Well, that's a whole lot of different ways you can bring these things in. And you might be thinking, well, wait a second, those types of provisions, because we have 404A1 and 404B1 really seeming to tell us that character evidence is inappropriate, maybe these terms are applied in a way that is very stringent, that the proponent of this kind of evidence has to show some really super high barrier to getting these things in. And as we get into the cases, I'll invite you to challenge my way of thinking on this if you choose. But I want to propose that that's actually not the case at all, that it's actually quite easy for the proponent of evidence to satisfy one of these exceptions or one of these provisions to allow other crimes, bad acts, etc., to come in under 404B2. There's a slight caveat to this rule, which is that in a criminal case, if the prosecution wants to introduce this kind of evidence, that upon request of the defendant, the prosecution has to provide notice of his or her intent to use that evidence. So note to any future criminal defense lawyers out there, in every single criminal case you have, one of the motions that will go to the court and a copy will go to the prosecutor, comes now the defendant and requests the prosecutor to announce his or her intent to use 404B evidence against the defendant. Why? Why in the world the rules just don't require the notice? Why they require the defense lawyer to file this perfunctory notice that you'll do in every single case? Because why wouldn't you? This seems to me just to set up a trap for new lawyers or lawyers who are lazy or forget the rules. It doesn't achieve anything by essentially requiring the defense in every single case just to file this piece of paper that they'll file every time. But note to future criminal defense lawyers, this rule says to you, whenever you represent a criminal defendant and he's been indicted or she's been indicted, you will send that piece of paper immediately to the court. And of course, with every motion, you'll send a copy to your opponent. So we're about to begin now looking at 404B and the very broad swath of evidence that it will let in.